How did the research motion case get this far? Some analysts say it's not surprising, given that our patent system was designed for an industrial world, and we're now living in a high-tech world. Companies patent ideas without ever intending to make anything, and then they sue companies that do for royalties. Does the system protect inventors or allow people to manufacture patents instead of products? Here with more is Bruce Sewell. He is Senior Vice President and General Counsel for Intel Corporation, and Paul Ryan, Chairman and CEO of Acacia Research Corporation. Just one note that we should share, both of our guests are currently facing each other in a lawsuit, and they can't talk about that particular suit. Unless, gentlemen, you would like to settle it here on this program and make some news, it's up to you. Bruce, let me start with you. With respect specifically to research in motion and NTP, is this a case where NTP had a patent but not a product, and RIM had a product and maybe infringed on the patent?
It's certainly a case in which RIM has a product, NTP owns a patent. The question that I think we have to ask is, where did NTP get that patent, and what have they done with it since they had it issued? I think the facts are that the company which has actually productized this and taken this technology to the world is RIM, not NTP.
Now, Paul, would you agree with that, or should an inventor who files for a patent, pays the money, does the search, and actually, puts an idea into a protective mode, just be totally disregarded because somebody else took it and ran with it?
Absolutely not. Certainly our U.S. law protects patent holders. It's what encourages innovation in America and makes America the knowledge-based leader in the world. Without a strong patent system, you wouldn't have small technology companies coming up with new innovations.
All right, but Paul, so what do we do about those companies, though, that may in fact just be in the business of filing for patents, never intending to create a product, but intending to sue some company that does make something similar?
Well, I would address that by saying America's leading universities, supported by tax dollars, represent a substantial portion of the innovation and patents in our country, and should large multinational companies simply be able to take that technology because universities aren't competitive with them?
Bruce, you want to answer that question? Because you are a large multinational company, by the way.
Well, indeed I am. Yeah. No, the issue is not around whether there should be wholesale taking of people's inventions. Of course, we support a strong patent system as well. The issue comes down to what kind of compensation are patent owners entitled to. The statute says that they're entitled to reasonable compensation. I would argue, and I think many would agree with me, that what NTP is trying to do to RIM today, which is to extort money from them based on the value of their entire product, as opposed to just the value of the contribution of NTP's single claim in a single patent, goes beyond reasonable compensation.
Yeah, Paul, what about that? I mean, if indeed BlackBerry has improved upon the process and has, or research in motion has, not only improved on the original patent, but created some proprietary materials or products or inventions of its own, why should it have to pay NTP royalties on the full value of that product, or even worse, be knocked out of business in the United States?
Well, it's the court, in this case, on the damages that determined the royalty rate, not RIM, and obviously the court thought that was a fair price for the portion of the technology represented in RIM's technology. That's usually the case. I think it's a red herring. I think in most patent licensing and most settlements of litigation, it is taken into account what the fair value of the technology is relative to the product.
Now, Paul, why do you think, and the judge was quite upset about this today, why do you think these two companies are having such a difficult time coming to an agreement?
Ego. It's very rare for these cases to reach this level of absurdity. From what I've read, certainly NTP had the ability to solve this years ago for a very modest royalty, and their continued insistence on willfully infringing the patents and gaming the legal system over 5 years has certainly put the patent holders in a less friendly mode. So I think they've created their own problem.
Now, Bruce, with respect to a company like Intel, I mean, when you are confronted with situations like these, your adversarial position with Paul notwithstanding, I mean, do you usually settle, or do you go to court and try to make these problems last as short a time as possible?
Well, we take this on a case-by-case basis. If we think that there's a problem with the patent and we think that we don't infringe, then we absolutely take it to court. If, on the other hand, we think that this was a patent which we innocently infringed, that we didn't know about, we believe that inventors are entitled to a just compensation, so we'll settle the case. The point that's important here, though, is to look at the injunction. The issue of royalties is one question. What's really holding up the NTP settlement now is this threat of injunction. We know that there was a figure of $450 million on the table. That was not acceptable to NTP. The reason it wasn't acceptable is I believe they think they can get more out of this judge using the threat of the injunction.
All right, gentlemen, I have to leave it there. Bruce Sewell, Paul Ryan, thanks for being with us today. Appreciate it.